Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Hague Visby Rules Defining Cargo Ships Obligation and Liability. Obligation to issue a bill of lading. Article 3, paragraph 3 provides that after receiving the goods into his charge, the carrier, the master, or the carrier again must, if the shipper demands, issue a bill of lading to the shipper showing, amongst other things, all leading marks for identifications of the goods as stated by the shipper before loading in his shipping note, provided these are visible on the goods or their coverings, either the number of packages or pieces, or the quantity or weight as stated by the shipper. The apparent order and condition of the goods. The carrier master and agent needs not insert any inaccurate statement on the bill of lading or give any details which he cannot reasonably check. Hence, the practice for statement to be made such as said to weight and shipper, load and count. Any bill of lading this issue will be prima facie evidence of receipt of the goods by the carrier as described, but proof to the contrary will not be admissible if the bill of lading is transferred to a third party acting in good faith. Article 3, paragraph 4. Any bill of lading issued after loading must be shipped. Bill of lading is if the shipper demands, provided the surrenders any previously issued document of title. An example, a received bill of lading issued when the goods arrive at a warehouse or depot before shipment. Article 3, paragraph 7. Carriers' rights and immunities. The carrier exemptions from liability, the carrier's right to deviate, and the carrier's right in respect of dangerous goods. Article 4, paragraph 2 grants 17 exceptions from liability to the carrier. Compare with the 6 under English common law. Neither or carrier or the ship will be responsible for loss or damage arising or resulting from act, neglect, or default of the master, mariner, pilot, or the servant of the carrier in the navigation or management of the ship. Fire unless caused by the actual fault or privity of the perils of the carrier. Perils, danger, and accidents of the sea of other navigable waters. Other navigable waters. Act of God, act of God, act of war, act of public enemies, arrest or restraint of princes, rulers for people, or seizure under legal process. Quarantine regulation, acts or omissions of the shipper or owner of the goods, his agent to representatives, stakes, lockouts, stoppage or restraint of labor, riots and civil commotion, saving or attempting to save life or property at sea, wastage in bulk of or weight, or any other loss or damage arising from inherent defect, quality, or vice of the goods. Insufficiency of packing, insufficiency or inadequate of marks, latent defect not discoverable by due diligence, any other cause arising without the actual fault or privity of the carrier, or without the fault of or neglect of the agent or servant of the carrier. But the burden of proof will be one of the carrier to show that his fault or privity, or the fault or neglect of his agent or servant did not contribute to the loss or damage. Article 4, paragraph 4 provides that any deviation in saving or attempting to save life or property at sea, or any reasonable deviation, will not be an infringement or breach of the Hague Visby Rules of the contract of carriage, and the carrier will therefore not be liable for any resulting loss or damage. Article 4, paragraph 6 provides that goods of uninflammable, explosive, or dangerous nature, if not properly marked, or if shipped without the knowledge or consent of the carrier, may be landed, destroyed, jettisoned, and rendered innocuous at any time before discharge. Such goods, even when shipped with the carrier's knowledge and consent, may be dealt with in this way without liability to the carrier, should they become dangerous. General average under the Hague Visby Rules. Under Article 5, nothing in the rules may be held to prevent the insertions in a bill of lading of any lawful provisions regarding general average. Most of bill of lading have a clause making the merchant or shipper aware that he may become liable for a contribution in general average. Exclusions of deck cargo and live animals from Hague Visby Rules cover. Article 1, Section C, exclude from items defined as goods, live animals, and cargo which by the contract of carriage is stated as being carried on deck on is so carried. Live animals are excluded from cover at all times. Cargo which is carried on deck without being stated as such in the contract will therefore be subject to the rules, as will cargo which is stated as being carried on deck but which is in fact carried below deck. Where the carrier terms and conditions of carriage incorporate the Hague Visby Rules, then in the absence of any terms expressly providing to the contrary, those terms will not cover live animals on deck cargo. A shipper of live animal or deck cargo should therefore make a special contract for the carrier and should specify state for deck carriage on his shipping note. So this is the end of the article. Don't forget to watch the first part. So bye bye and see you on my next video. Bye.